Good afternoon, everyone. We're going to be getting things kicked off in just a moment or two. We're just waiting for more people to be still connecting. Okay, we're going to start things off now. Thank you, everybody, for joining us. My name is Geoff Pollock, and I'm joined here with my good friend Bob Adorian. And this is the second in a series of webinars. The first one we had on the 28th of February. It was called Successful Closing Strategies. Today, we're going to talk about crafting the perfect APS. Like our other webinar, this will be later available on YouTube. We will share the link with everybody, and feel free to share the link with your friends and colleagues. Our next webinar will be on the 25th of April. So today we're going to cover a few different areas. We're going to talk about due diligence before signing the APS. We're going to go through the conditions to include and the conditions to avoid. We're going to go over the status certificate. We're going to talk about the hidden tax pitfalls. Then we're going to go into some war stories, and finally finishing up with a Q&A. If you have any questions, you can put them into the Q&A chat function now, and we will try and get to everyone's questions at the end. So allow us to introduce ourselves.
Well, let me start with introducing Geoff Pollock, my good friend, a highly experienced real estate lawyer. I was pleased to serve with Geoff as a bencher of the Law Society of Ontario, the regulator of lawyers and paralegals in this province. Geoff is not only a highly experienced lawyer, he has a business background with an MBA and has served our country in the military. I'm looking forward to learning from him today, and I welcome you all.
Thank you, my friend. And I think you're being a bit generous in terms of learning from me. My good friend Bob Adorian has forgotten more about real estate than I will ever know. If you are asking anybody in the province of Ontario for an expert in real estate law, Bob Adorian is one of the first names to come up. Bob is a current bencher in the Law Society of Ontario. He was the head of the real estate lawyers liaison group, and he is a member of what Bob likes to call not just the ABA, but the real ABA, not the American Bar Association, a far, far, far more important organization, the Armenian Bar Association. Bob, do you want to tell us a bit about due diligence?
Yes, some of it is required by law. You're all familiar with the FINTRAC requirements, but in addition, you also want to have all of the information that you'll need to make sure that your clients are approved for a mortgage, and that there isn't going to be any last minute issues with the underwriters of that mortgage. So knowing your client means verifying their identity through the identification requirements, their residency in Canada, their ability to buy real estate with regard to the Non-Resident Speculation Tax Act, and also preparing them for what's to come. And we'll talk about this a bit later, but telling them, no, do not lease a high-end car prior to closing. Do not change jobs in the weeks prior to closing. Do not retire in the weeks prior to closing, and we'll just talk a bit more about why that is important as we go along. Knowing what your client wants to do with the property, things like renting the basement for more income, will help you to determine if there's going to be a zoning issue. And as we go through, we'll talk about other aspects of this in the context of drafting the agreement.
Well, you know, there's one other thing in there in terms of the family situation that springs to mind, and that's in a situation that will one of the parties happen to be absent during closing? Is somebody working overseas, for example? Also, is this a situation in which the vendor is maybe an elderly parent, and this is a situation that you may want to examine? Should we put a power of attorney in place? You want to look at all of the possibilities that could happen in terms of interfering after post signing of the APS, and that could interfere with the ability to close the situation. I had a situation that I was in that we found out that our client who was purchasing the property, and it was going to be the matrimonial home, she was in fact married when we were told she wasn't married. Not a big deal. She was the only one going on title, but as you know, you would need consent in order to put a mortgage on the property. Problem was, her husband was in Tehran at the time and was a professor there. We were able to get the consent done, get the KYC done, identify the client, but it took a lot of effort and a lot of hard work and needless stress that happened just a few days from closing. It's best to preempt these things right at the time of the agreement of purchase and sale. So let's talk about some conditions. And everybody knows there's almost always a condition in the agreement of purchase and sale dealing with chattels. And it's that they will assume the hot water contract if it's a rental. That's been a standard clause in an APS for a long, long time. But if you are representing the vendor, you should expand this, because these days it's not just the hot water tank that has these rental contracts. A lot of people have water purification systems. They may have a complete HVAC unit. And if it is not included in the agreement of purchase and sale, then this will need to be discharged. There are things that are registered on title. And the companies that are people like the Reliance, Home Comfort, NPure, they tend to have really, really, really strong buyout clauses that can run in the tens of thousands of dollars. And what happens is they won't be aware of this till afterwards. They'll say, oh, yeah, that's right. We signed that contract, so and so and so and so. But they will need to buy it out. And then all of a sudden, that could be $10,000, could be $20,000, could be $30,000. Now, if you're dealing with a multi-million-dollar house, it shouldn't be a huge issue, but it is. And one of the things is this tends to happen a few days before closing, and it's a surprise. Surprises when we're dealing with real estate are never a good thing. Now, don't get me wrong, surprises can be great. I had a few years ago, we took our kids, we told them, hey kids, you're going to have a sleepover at Grandma and Grandpa's. And we drove to the airport and hopped on a plane and went down to Florida. We didn't tell them that they were going to Florida for Grandma and Grandpa's. Great surprise. Also on the subject of family surprises, I got a call about an hour ago from the school. When the school calls you, it's never a good thing. They're never calling and saying, by the way, Mr. Pollock, we just want to let you know you're doing a fantastic job as a parent and keep up the good work. No, of course, our youngest daughter was hurt and needed to be picked up from school. Those are never good surprises. But as bad as school surprises are, real estate surprises are worse. So at best, your client is going to be stuck with a bill, $5,000, $10,000, $20,000. At worst, um, may delay closing because trying to get discharges from these organizations can be very, very problematic and can delay closing a few days, may even prevent closing. And the other thing is that changes how your client looks at you and the entire flavor of the transaction. It doesn't matter that you were able to sell the property $50,000 over asking, $100,000 over asking. What the client will remember is that extra $5,000 or $10,000 that they had to pay. And that will turn what would otherwise be an extremely happy client who will go out and tell other people about what a great agent they have into a very, very unhappy client. And at worst, it can lead to litigation against the agents. You didn't tell me this. You didn't, you should have done it. Now, are they going to be successful on that aspect? No, they likely will not, but they may be under the aspect of something else. They could complain to the regulator, and these are problems you don't need. So what you need to do is, again, what Bob said earlier, KYC, 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 know your client, ask them, is it a rental for an HVAC unit? Is it a rental water purification system? And then include it in the APS. It's a good idea to just, frankly, if you don't know, just include it in the APS anyways. So another important condition is an assignment clause. We strongly recommend that you put in there the clause, the ability to assign the APS or to add additional parties. And Bob will talk a little bit more about this as well. He touched on it a bit in terms of financing issues, but this can mean the difference between closing a deal and not closing the deal should a financing clause arise. Another thing you may want to include is to have, if you can, contingency clauses and home inspection clauses. If you are representing the vendor, it's a good idea, have a home inspection done. Have it done before you even list the property, then have the home inspection report available right there on the table during any open house, or provide it for anybody going through the property. Now, one thing that is critical is if there are defects in the property. So for example, if there was an inspection report done and there was, say, asbestos that was found, these things need to be disclosed. And what you should do is you should send an email to your clients, create a paper trail saying we need to disclose this to every buyer, get their written permission to do so, then have it disclosed. The odds are, if you are going to be dealing with a multi-million-dollar home and there is an asbestos cleanup that is required, maybe it'll be $5,000, $10,000, $20,000. In the scheme of things, it shouldn't be a big deal. However, if it's not disclosed post-closing, they may come after the vendor and say it was a latent defect you had to disclose. Then the vendor may be looking to their agent. If there is a potential claim against them, launching a third-party claim against you. Again, this can be helped and eliminated with proper communication, documenting everything, document. And this could, again, change something. Maybe they're being sued in small claims. I've got a situation right now. Client is being sued in small claims court for $20,000. Property was sold for $2.5 million. Doesn't matter. Everybody's unhappy, and whereas the agent did a really good job, got the sales way over what it was worth asking, but this little thing that happened at the end changed the flavor of the deal entirely, and it could have been prevented easily. So this turns again, nobody likes surprises when it comes to real estate transactions. Now, other things talked about things to include. Let's talk about things to avoid. You want to avoid ambiguity. You want to avoid vague terms. And I know everybody is looking down the slide and saying, rabbits? What do you mean, rabbits? Well, let me tell you a story. Now, first of all, I think everybody who is here probably is in a situation in which they were doing a favor for a friend and doing it at a discount. And probably everybody who's done that is like, oh boy, the good deeds never go unpunished. And when every time you try and do a favor for somebody, problems crop up. So that's what happened to me. I was doing a deal for one of my closest friends in the world. The godparents, my former roommates, 3 years in university, the godparents of our eldest child. And my wife and I, we're the godparents of one of their children. And when we were going to sale, the real estate agent included a term on the agreement of purchase and sale that included the rabbits of the house. I am not kidding. The real estate agent, who incidentally was his sister. So what happened was they had a few rabbits outside. The purchasers were going through the property. They had a young daughter. The young daughter said, "Oh, bunny, 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 bunny." And so they then said, "Oh, let's just include this in a term of the agreement of purchase and sale." Great. What could go wrong? What happened is they actually back onto a ravine. And not just little girls like rabbits, but coyotes really like rabbits. So come time to close, day before closing, rabbits were a coyote's lunch. So what do we do? The agreement of purchase and sale calls right there for the rabbits. I called up the other real estate lawyer and said, "We've got a problem here." And so it went to a situation. He's like, "Well, it said rabbits. It didn't say, did it say these rabbits?" And so to those people parents who've ever maybe had a fish that died and magically another fish appeared, or a turtle and a replacement turtle got there were replacement rabbits. However, in the town of Fonthill, Ontario, it's a little bit challenging to buy rabbits at the last minute. So my buddy needed to go out to a number of pet stores, and I think he had to go to St. Catharines to try and buy some rabbits at the last minute. So if you're gonna include a chattel, don't include pets. Don't include farm animals, okay? So things to avoid. At all costs, avoid rabbits, especially when you live beside coyotes.
Can I hop in for a moment about the vague terms?
Absolutely, my friend.
Bear in mind that the standard ARIA form has provisions in it that have been tested. They've been tested by time, by the courts, and they are sound provisions. When you want to draft something that's customized, you are to a certain extent doing it at your own risk, even though your client wants it. There's no harm in reaching out to their lawyer and saying, "Can I run this by you?" An experienced real estate lawyer will want to work with you on those specific provisions before pen is put to paper rather than after. That's just a safe practice that I would encourage you. And I think I've got one that's similar to the rabbit story. My clients bought the house, they were happy, they moved in, and then the nosy neighbor came over and said, how do you feel about the fact that they didn't take grandma?" And the buyers asked, "Where's grandma?" "She's buried in the backyard." And suddenly they didn't want the house anymore. And so that was a situation where there were a lot of lawsuits, and in the end, the title insurer agreed that that was a defect, and they bought the house from the buyers and then put it up for sale with full disclosure that that grandma was getting free rent 6 feet underground in the backyard.
Well, also with this, a good idea is don't leave grandma, probably a best practice.
Yeah.
Yeah, you could probably get away with leaving the rabbits in the backyard 6 feet under or 6 inches under, but probably not grandma. So this best practices: don't leave grandma, and if you do, disclose grandma.
Status certificates. Um, by law, a condominium corporation is obligated to produce a status certificate to a subsequent buyer. And it's a snapshot of what's going on with that condominium corporation financially, in terms of court cases, in terms of whether or not the board thinks that the reserve fund is is good enough, if it's adequate, and if they're planning any increases in the monthly fees. So the lawyer reviews it. The first thing they look at is, what are the monthly common expense fees, and do they correspond with what the seller has told you, what's represented in the agreement? And then, how much is the reserve fund? Has the reserve fund study been done? Is there any litigation? And of course, the rules of the condominium for things like pets, barbecues, visitor parking, etc. So lawyers review them. They give realtors and their clients an opinion about any issues um, that may be of concern again. And once again, this is a very big know your client area. One of my favorites, and some of you have heard me say this before, there are certain people who I love, and I always pick on hairdressers, but hairdressers, bus drivers, lawn care people, they do a good job, but they should not be giving legal advice. And people will say to me, well, I know that it's no pets, but my dog is a service animal. And so they don't make their offer conditional on having that animal approved by the board of the condominium corporation. The sad fact is that there is very little um, regulation around that. Um, Ontario does not issue ID cards for certification of service animals other than guide dogs for people who are visually impaired. And other than that, it's up to the condominium board to determine whether they are satisfied that this particular pet meets the requirements. So if you've made an agreement without a condition for that, and then the board says, no, we're not satisfied, you're going to have an unhappy customer.
Absolutely. And I put in the specific provision about the barbecue. Now, people who know me know how much and how passionate I am about my big green egg. I call myself an egghead. And I am not saying that it would be more important to be able to barbecue on a patio than it would be to have my children with me. I am saying it's of equal importance to being able to have my barbecue with my children, but I'm not saying my barbecue is more important than my children. As a matter of fact, I often say that my big green egg is the fifth member of our family, and Sash, our youngest, is our sixth member of our family. So make sure if somebody really is passionate about barbecuing, for example, there's some condominiums that allow people to barbecue on but they may have a restriction to a propane barbecue, which personally I would say is not a barbecue, is heresy, but it has to be good old-fashioned lump charcoal. But find out what's important to your client. And then also, if you're the vendor, have the status certificate available. You don't want to have things delayed by taking 10 days or something like that. And if you're on the purchaser, one thing you can never go wrong telling your client that they need to have a little bit of a buffer, and in terms of their ability to service not just the mortgage on the property, but to pay the common expenses. It's never a bad idea to tell them that the common expenses will go up and that the reserve fund will go up. Don't know by how much, but make sure they're not in the position where even a marginal increase of 5%, 10% would turn it from something that is affordable to something that is unaffordable. And so these are some of the things to bear in mind with respect to the status certificate. Now, one other thing to talk about the status certificate is it is possible that if there's too much of a delay between when the status certificate is ordered and reviewed and the actual closing of the property, that the status certificate will no longer be accepted by the title insurance company or by the mortgagee. And in that case, a new status certificate will need to be ordered. The problem is if something happened in the interim. So for example, the condominium corporation just put forth a new reserve fund, and it radically changes the economics. If they're subject to a lawsuit, those are issues that could turn a deal into a no deal. So bear those in mind. Sorry about that. Bob, why don't you talk about the hidden tax pitfalls?
Yes, HST is always lurking in the background for real estate, particularly new homes, because the standard agreement for a new home will state that HST is in addition to the purchase price, unless you can establish to the satisfaction of the seller that you will personally occupy the property in their sole discretion. So if you're occupying it, but the seller thinks, I don't think you really are. I think you're just going to be there until the deal closes and then you're going to list it and sell it. They will assess HST in addition to the price. And then if in fact you do live in it for a year or rent it with a lease for a year, you can apply to have it refunded. Now that HST, if it's over 450,000 as a price, that HST is $24,000. However, strange as it may seem, if it's under 450, the HST could be more because there's a differential calculation. So you just have to let your buyers know about that. On resale homes, they are exempt from HST if they're residential, and that is completely residential, not mixed use. So the typical property on a main street where it's retail on the main floor and residential upstairs has to be apportioned. And generally speaking, Canada Revenue Agency will accept the apportionment if it's reasonable, but HST must be paid on the commercial portion. For pure commercial properties, HST is applicable. There is a way for the buyer to avoid the payment, and that is to register as an HST registrant and show proof of registration. But the standard wording in a commercial agreement is that unless they provide that proof of registration together with a declaration that they will indemnify the seller for any subsequent claim, then the seller must collect and remit HST. For capital gains taxes, everybody, including the hairdresser and the bus driver, knows that principal residences are exempt from capital gains. So you buy the property for your client buys the property for 100,000, and then many years later sells it for 800,000. That gain is not taxable if they lived in it exclusively. However, you still must report that gain on your tax return in the year of the disposition. Now we get to vacancy tax.
If I could just jump in
Go
there
ahead,
for
go
a
ahead.
second, Bob. I speak as the husband of an accountant, so it would be remiss if I didn't go through this in some detail. So it is critically important that you tell your clients to report this. And we've got a lot of real estate lawyers on the call. In your reporting letter, specifically put to your clients, put it in bold, that you must tell your accountant or your tax filer that you disposed of the property and claim the principal residence exemption. So you can go back in time and you can amend your tax return, but you can only do it for a few years. And what I suspect will happen is that once that reporting period is passed, that the CRA will start to examine the sales of property. And if people have not reported this, they will go and they can charge them penalties, but they can also charge them interest and the tax on it, even though there would be no tax that is due. But you didn't report it, and you only have a few years to amend your report, and therefore you owe us $1 million in capital gains taxes, even though you'd owe nothing if you reported it. You don't want to be in a situation, whether you're a realtor or whether you're a real estate lawyer, for your client afterwards to look to you and to look to your insurance policy and say, I didn't know, you should have told me. And then you can, if they do that, you can turn to them. You can have, this is my reporting letter right here, right there in bold. You need to report this. Don't make sure that your clients do not fall victim to this. And as a matter of fact, this is a little bit of a selling opportunity for you, because your clients may be comparing notes with their friends and said, oh, by the way, did you know that you needed to report this? Ooh, I didn't know. Our realtor didn't tell us about that. Our real estate lawyer didn't tell us about that. And they can say, well, you should really deal with my buddy Bob. He always puts that in his reporting letter. And this fantastic realtor, Sylvia, she always told us about that. So these are the things that you want to do, not just from a situation of ensuring you have happy clients, but also so your clients can also refer you more business. So look at it as a selling opportunity. Thanks, Bob. Do you want to talk about go over the assignment?
Sure. An assignment is typically done with a new home, new condominiums, where the builder said it's going to be ready in 2 years. 2 years became 3, 3 years became 4, and people's plans changed. Maybe there was a move, more children, that condominium is no longer convenient. And so they assign it, which means they say to somebody, pay me X number of dollars and I will assign this agreement to you. Those assignments require the builder's consent, but in addition, they are taxable. And the CRA has made recent changes to make them even more taxable. And if that's not enough, builders take the position that if you bought on an assignment, even though you're using it as your residence, they're still going to assess the HST, because they don't want to be assessed after the fact by CRA saying that the original buyer didn't occupy it, somebody subsequent who's not in the original contract did. So you should be aware of that with assignments. Get an up close and personal conversation with both the real estate lawyer and an experienced accountant on the tax consequences of an assignment sale for both the assignor, that's the seller, and the ultimate assignee, the end buyer.
Thanks, Bob. So let's talk about interesting cases. And these are war stories. So let me tell you about the first deal I ever did. And to those of you that know me, I say the same thing to every real estate agent out there. I say, when you are preparing the agreement of purchase and sale, there are a couple things to be wary of the date. First of all, never, never, never buy and sell on the same day. Secondly, never buy at the end of the month or the beginning of the month. Never, ever, 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 ever buy and sell or right the day before or the day after a long weekend. And for goodness sakes, no matter what you do, make sure you don't do all three. So my very, very first real estate transaction I ever did, brand new lawyer, brand new husband as well. So my mother-in-law is buying and selling on the same day. It's the 30th of June. It's Friday, the 30th of June, right before the Canada Day weekend. At that, as people know who deal with banks, if and frankly just about any other business, the day before a long weekend, you can fire a cannon through an office and you won't hit anybody because everybody takes a little bit of extra time off, whether they schedule the time off or perhaps they have a little bit of a I've got a cold. I can't come into the office. There seems to be a flu that goes around very often on the 30th of June. So my mother-in-law is not only buying and selling the same day, she didn't even schedule the move till then. So we are in a situation, we have closed the home that she's selling. She's not out yet of the home that she's selling, and what I find out afterwards, and then we're trying to get her into the new place. Well, of course, that transaction didn't close until the very, very, very end of the day. I think it was about 5 minutes to 5 before it closed. My mother-in-law has me on speed dial, is calling me every 2 or 3 minutes and saying, the movers are sitting here outside the house. I'm paying them by the minute. Why can't we move into the property? Give me the keys. And I'm like, I can't. And she's like, well, if you loved me and if you loved my daughter, you would get this deal closed right away. So it was a near run thing, but I am still married and my mother-in-law still loves me. I've had to work very, very, very hard in the past decade and a half. She now says that I am the favorite of her children, but she didn't say it on that day. So please, please, please don't try and buy and sell on the same day. Don't try and buy and sell at the end of the month, the beginning of the month. And the reason for not doing it at the end of the month, beginning of the month is these are the busiest days when probably a quarter or a third of all transactions happen and the banks are overwhelmed. Same thing with doing it right before, after a long weekend. Banks are overwhelmed and they're short-staffed. So, and you leave yourself no margin for error when you do this. War story number 2. Bob?
Underwriting for mortgages is important because if you're a shareholder of the bank, you want to make sure that your money is being lent out to people who are credible. However, there are some issues that will affect the buyers of property. And so just remember this basic rule: buyers want keys, sellers want money, and the rest of us who are involved, particularly realtors, want happy clients who will refer their friends, families, and mother-in-laws to you. So what could possibly go wrong? It's really important that you advise your clients not to make any significant changes to their employment, to their credit, or anything like that, because the underwriters of the bank will often run a credit report a week before the closing or call your employer to confirm the terms of your employment. And I have had all of the above happen. The credit report shows a high-end vehicle has been leased, and they say that monthly commitment now throws your credit out of whack. And so we are only now prepared to lend you less because you can't service that more, which means you have to come up with more down payment. Similarly, one of my horror stories was that the client was promoted within their own company, believe it or not, within their own company, from a salaried position to a hybrid position where it was part salary, part commission. The underwriter said, since you're so new, we'll only take the salaried part into consideration, which was less than the previous salaried part. So now you actually don't qualify for this mortgage and you need to have another person on the title. And this is a week before closing. We all find this out. And In that particular situation, they did find two people, two who would go on the title, and the mortgage company approved those two people. And they said, we need an amendment to the agreement signed by the buyer and the seller, adding these two people. Now, I know this is a bit complex, but if you can follow me, if there is not an assignment clause in the original agreement obligating the seller to accept this arrangement, they might say, you know, we think that this property has gone up in value. We're not signing that amendment. Whereas on the other side of the table, the mortgage company and their underwriter is saying, no amendment, no money. That's a situation you don't want to be in. The other one, and this is lost on many, many people, including the banks. They say, well, you add your grandmother on the title, but bear in mind that when you prepare that amendment as a realtor or as a lawyer, you now have a new client. And all of the know your client ID verification requirements come into play. And I've had it happen more than once where that older person had either expired photo ID or no photo ID. And the bank says, well, we need it. I say to the bank, you also have FinTrack obligations. You should have obtained it before you gratuitously decided that grandma could be added. Their response is, yeah, we didn't, but we still need it. And that puts both lawyer and realtor in a very difficult position. There are some workarounds that I could talk about with you sometime. There's too much detail to go into them here, but they are complex, they are time consuming, and with a week to go before closing, it might be difficult to pull that rabbit out of a hat. Geoff, sorry to mention rabbits.
And I think you're being generous if a week before closing.
Yep.
That could be 48 hours before closing, 24 hours before closing.
Yes. The next thing, there are some mortgages where you're instructed and say, we will only accept wet ink signatures. That's generally okay. We can have clients into our office, but sometimes we have already committed to the client that we can sign them up remotely. Maybe, grandma who has been added is in a seniors facility and is not particularly mobile. And if we get this curveball thrown to us, which says wet signatures only, we have to figure out how to deal with that. The latest one that we've seen several times in the last 2 months is that they add grandma or somebody to the title and say that person requires independent legal advice from another lawyer, which means you've now introduced another lawyer into the transaction who really has no interest in seeing your transaction done, only to protecting grandma. So that lawyer sits down with grandma and says, you're going on for 1%, you're going to be a 1% owner of this property, but you're also going to sign the mortgage. And in spite of your 1%, you're going to be 100% responsible for the full amount of that $800,000 mortgage, without telling grandma that's a remote possibility because the house is right now worth over $1 million. And that could be a problem if grandma says, I'm not as enthusiastic about this as I once was. And then I'm saving the best for the last. Some of you have experienced this painfully. I certainly have with some of my clients. They have a pre-approval based on the house being sold for $1 million, and they have an $800,000 mortgage, 80% loan to value, but then the appraisal comes in somewhat less. Sometimes 900,000 instead of $1 million, sometimes 800,000, and the bank will lend you 80% of the lower of the appraisal and the purchase price. So now at a 900,000 appraisal, they'll only lend you 720,000 instead of 800,000, and your client has to come up with the other 80,000. It's not fun, but you do you're best advised to remind your clients that that pre-approval has some conditions with it, with respect to employment, with respect to the valuation of the property. And I did forget one. And this is one that came totally out of left field. our client was employed for over a year as a policy consultant to a major organization. So they had the pre-approval letter, but then they had to provide a letter of employment, and the letter of employment said that they are employed here. They have been for a year as a policy advisor. And then the not so magic words, on contract. In other words, they were contracted employees. And the bank said, that's not what we bargained for. That's not what we were led to understand. We don't lend on contracted employees. Now, in fact, in her particular industry, you can only get jobs on contract because they're for a fixed term. Sometimes there might be 5 years, but they're still fixed term. So her mortgage just disappeared like this, poof. And she had to go to a Schedule B lender and pay more. And she was more interest, and she was upset with everybody, including, unfortunately, her lawyer. So I think it's important to have that heart-to-heart with the client and the mortgage broker, and just put out all the cards, have the employment letter ready in advance, and say, if there's any issues, tell us now, not after we've paid a $50,000 or $100,000 deposit, and there's no point in return.
Great points, Bob. One other thing that I just wanted to have one sort of other case to put is if you forget to include a clause about vacant possession. And this is critical because you don't want your clients all of a sudden, unbeknownst to them, to inadvertently becoming landlords. You should always put in a vacant possession clause into the agreement of purchase and sale, providing that's what your client wants. Now, of course, there may be a situation they're buying a duplex and they want to move into one of the units, and they want to have tenants in the other 2 units, or maybe they want to have 2 units for themselves, and they're relying on that income to help in terms of their ability to service the mortgage on the property. That's great. But you also, in that case, you want to have included the terms of the rental agreement to make sure it is a proper tenancy agreement and how much the rents are right there as a schedule. Because if it's not, if it's more of an informal agreement, the discussions about the underwriter / undertaker, well, maybe the underwriters don't accept that as the income. And if you are going to, and you do need vacant possession, then you need to let your clients know they need to schedule enough time in order to end the tenancy properly. So you need to, again, comes down to a timing issue. So tips for drafting the successful agreement of purchase and sale. And it comes back to what I said before, minimizing surprises. Surprises for real estate transactions are not good. Surprises for your children, good. You want to give a surprise anniversary gift on that trip to Florida at that time. I gave my wife for our anniversary, I gave her a Rolex. That was a good surprise. She was very happy. Mother-in-law was still a little bit angry at that time, but my wife was very happy. Great surprise. Real estate transactions, surprises, not good. Minimizing surprises, a lot of it comes down to pre-transaction due diligence. Start collaboration early with the real estate lawyer. Explain any potential title issues to your clients. If possible, include the conditions. It's not quite as competitive a market as it once was, but it's starting to get a little bit there. If you're able to include conditions, would be it financing, to then try and protect your clients as you can. And then consider having title insurance and suggesting this to your clients.
If I could mention one thing here.
Of course, Bob.
I think it's a good question to ask for a realtor. Ask the lawyer you work with, if they pull a property parcel, that's the first step of a title search, when they receive an offer for a sale, because that will tell you how experienced they are and how diligent they are. Here's what can show up. When the offer comes in, we're not closing for 6 weeks or 8 weeks. We pull the parcel register and we see an old mortgage registered in favor of a financial institution that no longer exists, that has been dissolved, or an individual like grandma put on a mortgage and she's now deceased. At least you want to have some lead time to deal with that, because they are not necessarily easy to resolve. And my all-time favorite is when I called the clients to ask, what about this? What about this mortgage with this company? Didn't the bank mail you something and say, have your lawyer register this? And they said, oh yeah, they mailed it to us. We had a barbecue, we had the thickest steaks, we drank beer, and then we had a mortgage burning ceremony. We put that letter from the bank on the barbecue and we burned it. It broke my heart, because that was the document that should have been registered in the land registry office. We were able to resolve that because we had some time. But you don't want to find a week before the closing, when you receive the requisition letter from the buyer's lawyer, that there's a title problem with something like that. So I think you should look for experienced real estate lawyers who will pull that parcel register themselves and alert you and deal with problems so that you don't hear about them at the last minute.
Great points, Bob. I've had to, on more than one occasion, scramble to resolve a situation for a now defunct lender. And as a matter of fact, just earlier today, Bob was dealing with a situation in which it was a private mortgagee, and the private mortgagee was deceased, and then trying to deal with the discharge of that mortgagee. Again, you need to have a lawyer who gets on it right away, who can deal with the situation immediately, and who, in the immortal words of Sergeant Pinsett, who was my drill sergeant when I was going through basic officer training, to move with a sense of urgency and purpose. So that brings us to discussing just for a moment or two about MASTERRE. And what is MASTERRE? Well, MASTERRE, we're a software as a service company that is real estate transaction management made easy. We are designed for the Canadian market and tailored to real estate brokers. Here's a problem that currently a lot of brokerages are using Excel and fillable PDFs for the trade record sheets, which leads to errors and duplicate data entry. MASTERRE, our software, will reduce human error and cut your paperwork by over 50%. Problem: coordinating the transaction, invoicing, trust accounting is really time consuming and it's challenging. With MASTERRE, you can approve deals, generate commission statements, reconcile trust accounts, all within our software. Problem: many other products are not designed to comply with the Ontario regulations and legislation. MASTERRE was designed by real estate professionals for seamless compliance, and we host all of the data right here in Canada. So now this brings us to our Q&A. We've got a few minutes left. One thing I just wanted to add, that all of the opinions that Bob and I expressed are our own and are not the opinions whatsoever of Tribunals Ontario. So we've got a question here. What would happen if a buyer cannot come up with the required funds before closing? Bob? Do you want to take this one?
Yeah, the textbook answer is
Bad
that
things.
bad things. They are in default. They can be sued. Their deposit can be forfeited. But quite often, parties realize that that's the case, and they might try to negotiate some kind of agreement, like a vendor take-back mortgage for some or all of the difference, if the first mortgagee permits that, which often in this situation they will, or they, shall we say, saw off the difference. So the 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 seller will agree to take something less, and the purchaser will come up with something more. I encourage people to do that, and sometimes my clients say, "You're not tough enough." But after spending 4 or 5 years in litigation and each side paying $100,000, they come back and say, "We should have listened to you." So uh, the art of compromise is one that says my expectations weren't met, but at least I had a result I can live with. But the the textbook answer again is, if you are not able to close as a buyer, you could be sued. You could forfeit your deposit, and if the seller sold for less, you could be responsible for the difference because you had already committed to buy for a certain amount.
One of the things this takes us back to is inserting an assignment clause. So if you are able to do that, then maybe they're able to bring somebody else in, maybe not necessarily a parent, maybe a brother, a sister, aunt, an uncle, somebody else that will purchase some of that property. That might be enough to get them over the finish line. So, and what you also want to do is, and this also comes back to what we said before about knowing your client, know their financial situation, know if this is going to be a stretch for them. And you always, Bob mentioned, I am a former member of the military. I'm a former officer in the Canadian Army Reserves. And one of the things they taught us about was Murphy. And Murphy's Law comes into effect a lot more than real estate law sometimes. So you want to build into it contingency. Um, we, um, we don't have time for any more questions. But if you want to send an email to Bob or myself, we would be happy to answer any questions that you have. Thank you, everybody, for joining us today. Just to remind you, our next presentation is on the 25th of April. And if you have any suggestions about things that you would like to hear, any topics that you would like to have discussed, we would be delighted to go over them. And I haven't got firm commitment yet, but I am really hopeful that Bob will be joining us once again. So thank you, everybody. Have a great afternoon. Take care.
Bye, everyone.